Okay, Chris, here's what I'm going to do for you since you're my bud and we've been friends for so many years. I'm going to read this to you while I'm looking at it, and so you can hear it and I can look for errors. In early 2020, Chris Alexander became aware of a decision made by ATU 757 that affected his and three members' seniority in a job classification that he was being trained for. Okay, good enough. This upset him, and he expressed his concerns in Facebook postings, along with participating and promoting the signing of a petition for members to opt out of the union. He stopped his participation and promoting of signing a petition in May of 28. You might want to change this to signing the petition instead of a petition. ATU, see what I'm talking about right there. ATU 757 executive board officers were not pleased with Chris Alexander's actions and shown their displeasure in many ways. Exhibit R7. So you made sure that exhibit is actually the right one, I'm sure. In meeting minutes of May 20th, the executive board states he is raging war on the union right now. In the same meeting, executive board officer Anthony Forrester makes a motion to suspend Chris Alexander and conduct an investigation on his actions against the union. Exhibit R6, and you check that to make sure that was correct. ATU 757 President Shirley Block states, quote, to try to get Chris to pull his head out and be an officer. Hold on, I got my copy. Hold on. All right, let me finish reading this before I make my coffee. President Shirley Block states that I do not take attacks on our union family lightly. When you use dues as a weapon and threaten to bankrupt our family, this is not an attack on me. You are attacking all of us. I find this action to be deplorable, and anyone who knows me know that I will not be influenced by such tactics. That's a direct quote, I take it. It sounds like Shirley, her use of the English language is not the best. Though she did not mention Chris Alexander by name, she references the actions of using the stoppage of dues to bankrupt the union. In July 3, 2020 article, she states, okay, what article? What? You might want to define that article. Where is it? I take more issue with the officer using that misinformation as a weapon to get people out of the union. Though she did not mention Chris by name, she referenced that it was a male executive board officer having issues with his seniority and using that information to get members out of the union. Though Chris Alexander stopped participating in the petitioning in May of 2020, ATU executive board officers continued their statements until he was removed. Validity of the opt-out request. The question being addressed here is, by granting Alexander's email request to revoke his dues deduction authorization, did Amalgamated Union fail or refuse to comply with ORS 243.846 or ORS 243.672(2)C? ORS 243.806.6 clearly states the terms of how a public employee's authorization for payroll deduction revocation is to be addressed. Chris Alexander's original signed payroll deduction authorization form does not provide the terms to specify the manner in which the authorization can be revoked. Therefore, the terms of the revocation are as follows. Delivered to the headquarters of the labor organization, a written statement of revocation, and originally signed. These three conditions provide a test for the labor organization and the public employee to use to determine if the revocation of the payroll deduction authorization is to be recognized. The complainant agrees that on June 15th, email Exhibit R8, Exhibit C2, is recognized by the state as a valid written statement that has been delivered to the headquarters of the labor organizations provided by RS 84 and 847. RS 848. Now you got to be a lawyer. Defines the state's recognition of an electronic signature as an electronic sound, symbol, or process attached to or logically associated with the record or executed of the adopted by a person, or by a person with the intent to sign the record. Exhibit R8, Exhibit C2. The June 15, 2020 email contains no sound, symbol, or process. The respondent has failed to produce in evidence anything that supports the document is originally signed. Failing to contain the three components make this invalid revocation document and should have been corrected before acted upon. Let me see how they can argue with that. Whitney Stark, ATU 757 attorney, states in her opening statement, in fact, he previously tried to resign, and in that circumstance, he publicly sent his email to a group of people and then promptly rescinded it. In May 18, 2020 email, she references it appears that the email was sent to Shirley Block, ATU 757 president, and the rest of them. I'm not going to go through all the names of them. I'm not going to go through all these names. All the names and emails were sent to ATU executive board officers or staff. It does appear the email was sent publicly. Whitney Stark continues to state, but in the case he didn't send it publicly, he sent it privately to Daniel Bauer, who is the individual at the union who manages and runs memberships and opting in and out. Of the membership, and Mr. Alexander knew that. This is a quote, so we don't need to, as long as you got the quote right. He knew who Miss Bauer was and what her role is. So Miss Bauer, as she's required to do, complied with the request to leave the union. Whitney Stark states shortly, in obeying, and of course you've checked all of these, you've already cross-referenced it. In obeying Mr. Alexander's request, Miss Bauer did not do some sort of capricious manner designed to harm him. She acted consistently with ATU policies in her practice of handling resignation requests. Exhibit blah blah blah, section this, blah blah blah. Officers desiring to resign first shall first submit the resignation to the executive board of the division. If the board finds the reason for the resignation justifiable, they shall recommend to the membership the acceptance of the resignation. But no resignation shall be accepted so long as all of their accountable responsibilities are not properly adjusted with the division. The May 18, 20 email falls within the protocol guidelines as set forth by the bylaws. Yet, ATU 757 allowed this email to be rescinded and not acted upon. The June 15th email does not fall within the protocol guidelines set by ATU bylaws, and ATU acted upon it immediately. This email was not addressed to any executive board officers, and Daniel Bauer had no authority to remove him. Right. From these things you quoted above, correct. A total of 5 emails that addressed opting out of paying dues and or leaving union membership. This is an email from Eric Torgerson requesting to only stop the authorization of payroll deduction and to no longer take union dues from his checks. This was dated December 12, 2019. There are redactions within the exhibit, making it difficult to understand the full conversation that took place. It appears that the email was sent to Mary Longoria and CC'd to Daniel Bauer. There does not appear to be an original signature on the document. There is no indication of attachment. ATU acted upon the document and advised TriMet to suspend his dues. This is an email from Chris Alexander requesting to resign his union spot. The email was sent to the executive board. ATU did not act immediately, and Chris Alexander later retracted that. This is an email. Okay, we're talking about exhibits here, so you know what these are, not me. This is an email from Chris Alexander dated June 15th, yet this time is only requesting that he no longer wishes to pay dues He no longer wishes to pay dues and for ATU to stop deducting dues from his paycheck. He also states he wants it effective July 1st, and he does not give up his union spot until his term is up. To understand what he means by saying union spot, look at his May 18th, 2020 email. His subject line, resignation from my union spot, and the email that defines his spot. Jesus Christ, it's like a lawyer's document. I tell you, Chris, you should have gone to goddamn law school. You can still go. This email exhibit was addressed only to Daniel Bauer. In the testimony, when Daniel Bauer was asked when she got the email, she stated, with this one, I processed, I would any other opt-out request. I sent the notice to April, my payroll contact. I replied and copied an officers and staff notifying them of Chris opting out as a member. Then I changed his status in NUMS to a non-member. ATU acted upon this document immediately and advised TriMet to suspend his dues deduction while changing his membership status from member to non-member. This was done June 15th from the evidence and testimony presented. This is an email from Michael Bruner dated July 20th requesting opt-out of the union dues. The email was sent from Daniel Bremer and does not appear to be any signature or attachment to the email. Daniel Bauer replied asking the member to put their request in writing and send it to the union office. The only action ATU 757 took was to advise the member to submit their request in writing and send it to the union office. This is an email from Andy Suvenvong, dated July 29, 2020, request to opt out of the union and no longer take dues from his paycheck. This email sent to Daniel Bauer. There doesn't appear to be any signature or attachment to the email. Daniel Bauer replied asking to put the request in writing and send it to the union office. The only action ATU 757 took was to advise the member to submit the request in writing and send it to the union office. Of the 5 emails that have been submitted into evidence, only the last 2 were handled in a consistent manner. The first email, evidence shows ATU 757 immediately acted and advised TriMet, advised is a spelling there, TriMet to suspend payroll deductions from being taken from the person's paycheck. Evidence does not show the person's membership status was changed to non-member immediately. The second email shows that I'm in the middle of something, just so you know, but yeah. The second email shows evidence that ATU 757 did not act upon it immediately and allowed a person to resend the original email. The third email, evidence and testimony, demonstrate that ATU 757 acted upon this immediately by advising TriMet to suspend dues from being taken from the person's paycheck and changing his membership status from member to non-member shortly after receiving the email. The fourth and fifth email were both responded to by advising the individuals to send their request in writing to the union office. There's no evidence that the membership status was changed or that TriMet was notified to suspend dues from being taken out of their paychecks. This demonstrates inconsistency upon how ATU 757 addresses such requests. When membership status was changed, Whitney Stark questioned ATU President Shirley Block, did you understand that he was no longer an officer as of July 1st? Block, yes, because of what he said in his email. Bruce Hansen questioned Chris Cordova as to when Chris Alexander was no longer a member. Cordova responded, I think initially, I would say July 1st. The union did not fulfill that request. The International has said since that it was effective immediately. The actual date that Chris Alexander was no longer a member is an important fact to establish. Whitney Stark questioned Krista Cordova. What is your understanding of her authority to appoint him in reference towards the replacement and as unable to make out what was said here when Chris was a non-member on July 1st? Cordova responded, I believe based on that date there was less than 1 year in the term for that executive board position, and therefore there doesn't have to be an election, so she can appoint the interim officer. and that is based on Constitution and bylaws. That means if Chris Alexander is no longer a member July 1st, then ATU can freely pick the person they wish to fulfill the interim position instead of being required to have a costly election, and allowing members to vote for who the members want to fill the position. June 22nd and June 23rd, Chris Alexander sent an email. June 22nd, sent an email. The June 22nd email was only to Daniel Bauer, instructing her that he wished to retract his decision to bail out on the union and give up on the members. He also asked for instruction of what he needed to do. Daniel Bauer responded June 23rd and did not copy the communication to other ATU officers and staff. She advised Chris Alexander to take it up with the top 3 officers to proceed. He sent AT Shirley Block, Hunt, and Longoria a request to retract and asked how to resolve the issue. There's no evidence that supports ATU responded to those. Daniel Bauer was asked what she did next when she received Alexander's June 15th email. With this one, I processed as I would have any other opt-out request. I sent the notice to my April, my payroll contact, and I replied and copied our officers and staff, notifying them that Chris opting out as a member. And I remember I changed the status in MOOMS as a non-member. This demonstrates that Daniel Bauer changed Chris Alexander membership status from member to non-member on June 15th and not on July 1st. The ATU International letter states, by the time you sought to rescind your resignation, you were neither an ATU member nor a local union officer, so you could not be restored to either, though your belated attempt at rescindment. So the ATU International said, fuck you. The letter also states, because you were no longer a member of the union, you were therefore outside the protections of the GGL or the LRMDA. This is no mere technicality, and union membership is required in order both to be protected and to hold a union office. ATU 757's action changing his membership status from member to non-member in the MUM system, along with his refusal to respond or allow the retraction of the June 22nd or email or June 23rd email, demonstrates that ATU 757 treated Chris Alexander as a non-member effective June 15th. The July 1st is the only being stated so that ATU would have the freedom to freely appoint the person they want to fill the position rather than go through the election. Chris Alexander's June 15th email sent to Daniel Bauer with the subject line opting out notice. He makes very strong statements in the email. I, Chris Alexander, wish to stop paying my dues effective July 1st. 2. I do not give up my union spot until my term is up in June 2020 or until the members vote me out, since the bylaws and Constitution don't mention or reference stopping dues paying while in office, only if running for office. 3. I do not authorize any dues to be taken out after July 1st. His first statement is his freedom of speech to say that he wishes to stop paying union dues starting July 4th. Until he does not pay his dues, he is still a member and is provided within the rights of the Constitution. ATU 757 bylaws, section 17, second to last paragraph, says members in arrears to the International Association or the local division for 30 days may be suspended from membership and removed from employment in compliance with the constitutional and general laws, as amended under the current labor agreement. ATU 757 bylaws does not make reference towards ATU Constitution and general laws, and in there it does not contain clear language about being arrears and how to address it. The ATU Constitution and general laws were not submitted into evidence, so the bylaws language is what needs to be used. The Constitution and general laws were not submitted to evidence, so that the bylaws language is what needs to be used. That's a little bit fuzzy. I know what you're saying, but it's a little bit fuzzy. Chris Alexander's was in arrears from July 1st to July 8th. He did attempt to pay his dues on June 22nd, and on June 23rd, ATU 757 would not respond. He was not in arrears for 30 days, yet he was suspended and replaced as executive board officer. His second statement states he does not give up his union spot. His May 18, 2020 defines what he means union spot. The subject line, resignation from my union spot, and the body of the email identifies Powell Executive Board. This should clarify that his union spot is the Powell Executive Board officer. His term at that time was actually from July 1st, 2018 through June 30th, 2021. Stating June 2020 was a typo. Keep in mind that he was angry at the time of typing this. With this clarification, his second statement, number 2, is him stating that he was to maintain his executive board position. His third statement simply identifies he is no longer authorizing dues to be taken from his paycheck. It is understood that ATU 757 has a deadline with TriMet as to when any changes can take place. It is also understood that deduction of dues is taken out of the second paycheck of the month to pay for dues of the month following. TriMet pays its employees every 2 weeks. That means in some months, TriMet will send out 3 paychecks for an employee that month. Dues are always taken out of second paycheck of the month. That means the second paycheck in June will have dues deducted that will pay for the full month of July. Daniel Bauer explains this in a testimony, and there it is. No matter what deadlines ATU 757 has met with TriMet about the payroll deduction changes, ATU still has the duty of fair representation. That's FAIR. Representation to the member. Whitney Stark asked Daniel Bauer in testimony, the union doesn't prorate by day in a given month, right? People either pay a full month's or dues or not. In other words, you can't pay a half a month's dues. You either remember for a whole month or not. Is that right? Bauer, yes. Whitney states it right there. You either remember for a whole month or not. Yet Chris Alexander membership status was changed from non-member in MUMs, and he was no longer permitted rights as of June 15th. Ooh. Well, that's a good point, isn't it? Whitney Stark, in her opening statement, states, nor has the union engaged in any other unlawful actions here. The union has not conditioned membership on dues deduction. Again, there is evidence in this hearing is going to show that Mr. Alexander, the evidence in this hearing is going to show that Mr. Alexander can understand what she said. Okay, that he's referencing the, you're referencing the audio tape. To join the union, he did so by offering a check as payment for which the union expected. And another member who I do believe is being called at witness today has also requested a direct payment of his dues, and the union has agreed to do that and accepted a check from him. So there's no conditioning here except they're out alleging that. Okay, Christopher Day first became ATU member in 2007. Sometime in 2017, he stopped payroll deduction and did not maintain paying his dues. He was removed as a member for failing to pay his dues. On June 21st, 2020, Chris sent an email exhibit along with fax to Mary Longoria requesting to rejoin the union. On July 28th, Chris sent an email to Longoria because she had not heard back. Later that day, Daniel Bauer emailed Chris replying to the email that he had sent to Mary. She stated that to join, Chris was required to fill out the application she attached, send it back to the union office, and she would handle it from there. Chris replied that he did not want payroll deduction, and he wanted to pay the dues himself. That boy, Chris. Yeah. I'm sorry. He also pointed out that the application only allows for payroll deduction authorization, and by filling out that application, he would be authorizing payroll deduction. Mary Longoria then responded, stating that the application being used is approved by the International and is a regular application and must be filled out. She further states the application is not negotiable. In August 20, Chris reached out to the Freedom Foundation. I'm sure they love that. And asked for assistance with addressing his application issue. On September 20th, the Freedom Foundation responded and sent ATU a letter as representative for him. October 2nd, 2020, ATU responded and provided a different application that did not require. Wow, that's pretty good. That's pretty good, Chris. You twisted their arm and won. Of course, you had. See how it works. You can't do these things as an individual. You need organizations. Individuals have no power. Chris then filled that application and returned it to the union office with a copy of his bank confirmation showing the paying of dues. When Daniel asked how Christopher Day's membership application was processed, she stated, Chris Day, I believe, had issues or concerns with being payroll deduct. And so I believe it went to International, and there was direction given to him to provide him the option to pay us directly each month as a direct pay member versus payroll deduction. This demonstrates the difficulty Chris had to become a member is not authorizing payroll deduction. The application that ATU presented Chris when he first asked is the only application ATU currently uses for any person who wants to join ATU. The application is a combination of application and authorization for payroll deduction as one. Filling that out automatically grants payroll deduction. No other application is made available. When the applicant asks for another way to pay dues without payroll deduction, the union typically responds that it is the only accepted application. If an applicant obtains legal representation and that representative requests for a way to join without authorizing payroll deduction, is that a period? ATU 57 will contact ATU International, and ATU International will instruct ATU to permit that person to apply and supply a form. Okay, from the International. So the International provides the form. The evidence shows ATU 757 makes it extremely difficult to become a member without authorizing payroll deductions. It also shows that when a member requests to stop unauthorization of payroll deduction, ATU maintains a running practice to change the member's membership status from member to non-member. Even when the member is still current on their dues every month, the revocation was submitted. This demonstrates that ATU 757 does not view that authorization of payroll deduction is independent of membership status. On July 8th, ATU appointed Mark Harrison as interim Powell executive, replacing Chris Alexander. More to come, going to bed. Okay, duty of fair representation to assure the valid revocation is being acted upon. The revocation is the original written signed document sent to the labor organization headquarters that all revocations are handled by the same member, and that membership status is not changed until the dues have expired. That applicants or members can start or stop authorizing a payroll deduction without affecting membership status. All right, well, I see your case. They didn't follow the rules. Now, will that actually hold up? I don't know. I mean, you know how these things go, Chris. You know, the judge whoever is looking at this will interpret the rules the way they want to do it. You know, strict standard of applying the rules by the letter of the law doesn't always work, as we already find out many times. But there you go. Listen to that and see how you like it. See how does it sound to you?